An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Gonzales versus Raich, 2005. In 1996, California voters passed the Compassionate Use Act, which legalized marijuana for medical use. California's law conflicted with the Federal Controlled Substances Act, or CSA, which banned the cultivation, possession, and distribution of marijuana. In 1998, the federal government sued to enjoin the operation of the Oakland Cannabis Buyers Cooperative. I became one of the lawyers representing the OCBC. We argued that the CSA exceeded Congress's powers under the Commerce Clause. However, there was an obstacle to our claim. Since money in marijuana was changing hands in the cooperative, this was clearly economic activity. My co-counsel, Robert Raich, suggested that we should bring a lawsuit in which marijuana was neither bought nor sold, but merely gifted. I wholeheartedly agreed. As it happened, Rob's wife, Angel Raich, was suffering from several intractable illnesses, including a brain tumor, which had caused a wasting syndrome. Her weight loss threatened her life until a nurse suggested she try marijuana. Using marijuana allowed her to gain weight and strength. Our legal team brought a civil suit to enjoin the application of the CSA to Angel Raich, as well as to Diane Monson, who used medical marijuana to relieve her back pains and spasms, which had not responded to conventional therapy. Critically, neither plaintiff purchased marijuana. Angel's caregivers grew the marijuana and gave it to her at no charge. Diane grew her own plants and thus did not have to buy it. Therefore, we contended that under the limiting principle established by Lopez and Morrison, Congress could not regulate this entirely intrastate, non-economic activity. And because we took care that no items used to cultivate the marijuana had ever traveled in interstate commerce, there was no jurisdictional hook. Although we lost in the Northern District of California, we prevailed in the Ninth Circuit, and the Supreme Court granted cert. Before the Supreme Court, the Bush administration was represented by Solicitor General Paul Clement. He argued that the local cultivation of marijuana is economic activity because homegrown marijuana substituted for marijuana that could have been purchased in the interstate marketplace. For example, because Roscoe Filburn grew wheat on his own farm to feed his livestock, he did not need to purchase that wheat on the interstate marketplace. Likewise, because Diane Monson grew her own marijuana, she did not have to buy marijuana on the interstate marketplace. This framework was known as the market substitute theory. We responded that Wickard was distinguishable. Unlike Angel and Diane, Roscoe Filburn was engaged in commercial farming, which was an economic activity. Furthermore, if anything that serves as a substitute for goods or services obtained in the market can be considered economic, there would be no limit on Congress's power because nearly any activity we do for ourselves can also be provided by a commercial service. And the Supreme Court in Lopez had already rejected any theory of enumerated powers that lacked a limiting principle. During oral argument, some of the justices seemed open to the market substitute theory. Justice David Souter suggested that whether or not an activity was economic depends on whether it had an economic effect on the national economy. He then equated the economic effect on the interstate market of Angel and Diane's homegrown marijuana with that of Roscoe Filburn's homegrown wheat.
If there would be a large market effect, it makes no more sense to call this non-economic than Filburn's use.
To this, I responded that Lopez and Morrison stood for the proposition that the mere fact that activities may have an economic effect on the market does not make them economic activities. To identify
whether an activity is economic, you have to look to the activity itself. An economic activity is one that's associated with sale, exchange, barter, the production of things for sale and exchange, barter.
So, for example,
prostitution is an economic activity. Marital relations is not an economic activity. We could be talking about virtually the same act.
We don't say that because there is a market for prostitution, that therefore everything that has an effect on the market, because it substitutes for what can be obtained in the market, is itself economic activity. After this exchange, the justices dropped the market substitute conception of economic activity. Ultimately, the court ruled for the government by a vote of 6-3. The 4 progressive justices were joined by 2 of the conservative justices from the Lopez and Morrison majority, Justices Kennedy and Scalia. In his majority opinion, Justice Stevens did not adopt the government's market substitution theory of economic effect. Instead, he relied on Webster's 3rd New International Dictionary's definition of economic as, quote, the production, distribution, and consumption of commodities. Because Angel's caregivers and Diane were engaged in the activity of producing marijuana, according to Webster's 3rd, they were engaged in economic activity. So under Morrison and Lopez, Congress could regulate their activity. For this reason, the CSA was constitutional as applied to cultivating marijuana locally. Justice Stevens also adopted an alternative holding. Chief Justice Rehnquist's majority opinion in Lopez mentioned that the Gun-Free School Zones Act was not, quote, an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. Therefore, Justice Stevens found that, quote,
Congress has the power to regulate purely local activities when necessary to implement a comprehensive national regulatory program,
which in this case was the Controlled Substances Act. Justice Scalia did not join the majority opinion, but concurred only in its result. Nor did he adopt the government's market substitute theory of economic activity. Instead, he stressed that unlike the Gun-Free School Zone Act, which was invalidated in Lopez, the CSA could regulate even non-economic activity because it was essential to its broader regulatory scheme. Furthermore, he stressed that this doctrine derives from the Necessary and Proper Clause. So the court was required to defer to Congress's assessment that reaching such local conduct is necessary or essential. Quote, Congress could reasonably conclude, he wrote, that its objective of prohibiting local marijuana from the interstate market could be undercut if those activities were accepted from its general scheme of regulation. Note that in Raich, Justice Scalia found that the CSA was both necessary and proper to regulate the interstate drug market. In contrast, in Prince, he found that the Brady Act provision may have been necessary to regulate the interstate firearms market, but was not a proper means of doing so because it impinged on state sovereignty. We will study Prince versus United States in a future topic. In her dissenting opinion, Justice O'Connor rejected the court's broad definition of economic, which she said, quote, threatens to sweep all of productive human activity into federal regulatory reach. Quoting from NLRB versus Jones and Laughlin Steele, Justice O'Connor objected to the court's use of, quote, a dictionary definition of economics to skirt the real problem of drawing a meaningful line between what is national and what is local. She also questioned the court's and Justice Scalia's deference to Congress's claim that reaching such activity was essential to its regulatory scheme. Quote, if the court always defers to Congress, as it does today, little may be left to the notion of enumerated powers. Chief Justice Rehnquist, who was too ill from cancer to attend oral argument and who participated in the deliberations by telephone, joined Justice O'Connor's dissent. He died just a few months after the court announced its decision in Raich. Justice Thomas also dissented. In his separate opinion, he urged, as he had in both Lopez and Morrison, that the court should abandon the substantial effects test altogether because it was not consistent with the original meaning of Congress's enumerated powers. Quote, respondents Diane Monson and Angel Raich use marijuana that has never been bought or sold, has never crossed state lines, and has had no demonstrable effect on the national market for marijuana. If Congress can regulate this under the Commerce Clause, then it can regulate virtually anything, and the federal government is no longer one of limited and enumerated powers. Let's conclude by returning to our brief history of implied powers. Lopez and Morrison represented an effort to put the brakes on any further expansion of New Deal and Warren Court doctrines governing implied federal powers. Now, Congress could only regulate intrastate activity that had a substantial effect on interstate commerce if the activity was economic in nature. However, by allowing Congress to reach even non-economic activity as part of a broader regulatory scheme, Raich seemed to exceed the powers the New Deal Court had recognized in Wickard. As I stated at the opening of my oral argument, if the court accepts either of the government's rationales for reaching homegrown marijuana, Gonzales versus Raich
will replace Wickard versus Filburn as the most far-reaching example of Commerce Clause authority over intrastate activity.
And so it did. After Raich, one might have agreed with Justice Thomas that there was no activity Congress could not regulate so long as it was an essential part of a larger regulatory scheme. But then, in 2010, Congress passed another comprehensive regulatory scheme called the Patient Protection and Affordable Care Act.